In this installment, I, Dina Peat, am being interviewed by Jamie Paquin on the topic of bankruptcy and the commercial landlord.
So, Dina, I read in the news that another big fashion retailer is going under and has filed for creditor protection. They must have had quite a few leased locations. It's made me wonder, what can commercial landlords do when their tenant files for bankruptcy?
Jamie, that's an interesting question. Generally, it's not great for landlords when a tenant files for creditor protection. In Canada, federal creditor protection legislation, such as the Bankruptcy and Insolvency Act, i.e. the BIA, or the Companies Creditors Arrangement Act, i.e. the CCAA, are focused on ensuring that debtors are able to restructure their obligations and pay their creditors in an orderly fashion. As a result, landlords are restricted in their ability to enforce their rights under a lease as they otherwise normally would.
So what's the first thing that a landlord can expect if they get notification that their tenant is filing for creditor protection under the BIA or the CCAA?
Well, if a tenant is making a voluntary filing under the BIA, the first thing a landlord can usually expect is to receive a notice of intention to make a proposal. This is a notice that the tenant is going to make a proposal to its creditors for how it intends to restructure its financial affairs. Once this has happened, a landlord is restricted from taking normal enforcement steps under a lease. For example, once a tenant has filed, a landlord cannot terminate the lease on the basis of any pre-filing defaults. Landlords are also prevented from continuing with any legal proceedings or lawsuits they may have already started against a tenant in respect of a pre-filing default.
Got it. What about rent? Do tenants still have to pay the rent after they file?
Yep, rent has to be paid under the BIA from the filing date onwards. In the meantime, creditors, including the landlord, go and vote on the tenant's proposal. If the vote is rejected, the debtor goes into bankruptcy. If the proposal is accepted and approved by the court, there is usually some small distribution of funds to creditors who have submitted claims to the trustee. Unfortunately for landlords, that distribution is usually much lower than whatever arrears or lost future rent would have otherwise been owing under a lease.
I know that some landlords will just want to get their premises back so that they can move ahead and release the space. Is that possible?
Yes. During a proposal, a debtor can do something called disclaiming a lease, which is where they choose to terminate the lease and stop leasing the premises. The tenant has to give 30 days notice to the landlord. If that happens, the landlord will get a notice of disclaimer from the trustee in bankruptcy. Once the lease has been disclaimed and the landlord is again in possession of the premises, the landlord can then release the premises as they see fit. But it's important to remember that rent is still payable to the landlord throughout that 30-day period leading up to the disclaimer of the lease.
Interesting. Sounds like there are quite a few moving parts. Any other tips?
Sure. The best thing a landlord can do is to get ahead of any filing. Since creditors' rights are restricted once a debtor files for creditor protection, landlords should keep the possibility that a tenant might file for bankruptcy in mind and take steps to protect themselves, whether by enforcing their rights under a lease by terminating or applying security deposits before a tenant can file for creditor protection. Here, being proactive is key.
It sure is. Thanks, Dina.
That was me, Dina Peat, in conversation with Jamie Paquin on the topic of bankruptcy and the commercial landlord. If you would like to learn more, contact me on our website, dv-law.com.
This audio recording was a general discussion and should not be relied upon as legal advice.